other vulnerable groups to be delivered by Professor J. Longwa, Department of Political Science, Mizoram University. I welcome Professor in our midst, and I also welcome all of you for this session again. The lecture will take 15 minutes, then after that we'll have 5 to 10 minutes of discussion. So, may I now invite Professor J. Longwa to deliver the lecture, and I request all of you to pay attention to the lecture and get something from it.
As we have just heard from the chairman, today the topic should be rights of other vulnerable groups. And I would like to request you to pay attention to the lecture. As teacher, I cannot tolerate murmuring and gossiping in the midst of lecture. And if anyone is not interested in it, you have the freedom to go outside. So those of you who are here, I will kindly request you to pay attention to the slide and my lecture. What is meant by vulnerable groups? Vulnerable groups means weaker sections who are vulnerable to exploitation, who are vulnerable to discrimination, who are vulnerable to torture. And when we look into the political system in India, the vulnerable groups can be scheduled caste, scheduled tribe, other backward classes, then women, and many other weaker sections. But today, our focus will be on scheduled caste and scheduled tribe, SC and ST. And what is scheduled caste? So, scheduled caste, SC, it is the lowest among the 4 castes of Hindu Varna system. And other castes of the Hindu regarded scheduled caste as polluted caste, impure class, unclean class, which could not mix up with other. And other Hindu castes, they felt that if there is any scheduled caste or Dalit or in their midst, that means they are polluted. In such a way, puja has been conducted. Earlier, there was separate locality for these scheduled caste people. And there was separate path and separate route for these scheduled caste people. And these scheduled caste people, they could not work in the same road with other people. And if they have to pass through some localities, they have to produce some sound, then people will get ready, they will close all their doors and windows. And if anyone forget to close their doors and windows at the time when scheduled castes are passing through, they have to conduct puja with Brahmins. In such a way, these scheduled castes were discriminated. And these scheduled castes are also known as untouchable people, untouchable castes, polluted people. Gandhi called them, father of the nation Mahatma Gandhi called them Hariyan. And after independence, they also came to be known as Dalit. And this term, scheduled caste, this is the term recognized by our Constitution of India in Article 341. And in this Article 341 Clause 1, this Article 341 Clause 1 gives power to the President of India to notify the list of scheduled castes. And this list of scheduled castes in different states and union territory should be notified by the President in consultation with governor of the respective states. And in Article 341(2), Parliament is given the power to include or exclude any community from scheduled caste. Then, how scheduled caste has been defined in Article 366, Clause 24. It is clearly written here. This is the definition of scheduled caste in our constitution. So how it is defined? Scheduled caste means such caste, races or tribe or parts or group within such caste, race or tribes as are deemed under Article 341. That means any caste, group or nationality who are recognized by Article 341 of the Constitution of India, and notified by the president, they are scheduled caste. So that is the definition of scheduled caste. What is meant by scheduled caste. Then we shall move on to tribe, scheduled tribe. So what is tribe? Oxford Dictionary defines tribe as a group of people who are from the same race, who share the same culture, custom, language, and tradition. And for this tribe, all these tribal group and all these tribe, they had one, they were led by chief or hereditary chief. And for this tribe, the adjective tribal is used. But instead of the noun tribe, the adjective tribal is becoming more and more popular these days. And when we talk about tribe, tribals in mainland India and tribals in Northeast, they are different. Tribals in mainland India, popularly they are known as Adivasi. Adivasi is the popular term for naming those tribes in mainland India. And these tribes in mainland India, some are Negroid, some are Dravidian, and some Aryan in outlook. But tribes of Northeast India, they are Mongoloid. In such a way, these tribal people of mainland India and tribal people of Northeast India, they are different in various aspects. But though they are different in various aspects, they are covered by the common term. That means scheduled tribe. So the term scheduled tribe cover both these tribal in mainland and Northeast. Then what are the criteria? What are the characteristics which have been used for identifying tribe? That means those people who live in hill and forest area. People who are backward economically, educationally, and socially. Then those people who have distinctive culture and who are shy in nature to contact with others. That's why these tribal people, they were governed differently even during colonial period. So during colonial period, there were different acts which have been passed to govern these people, like Regulation 10 of 1822. Then after that, Bengal Eastern Frontier Regulation 1873, Scheduled District Act of 1874, Government of India of 1919, then Government of India of 1935. In such a way, even during colonial period, different laws and regulations have been introduced for these people. Then, how scheduled tribe is incorporated and how scheduled tribe is recognized in the Constitution of India. In Article 3421, President is given the power to notify the list of scheduled tribes in states and union territory in consultation with governor of the state. Then, in Article 3422, Parliament is given the power to include or exclude any tribe or community from this list of scheduled tribe. Then, Article 366, Clause 25 says that those tribal groups who are included as scheduled tribe under Article 342, they are scheduled tribes. So, this is how the term scheduled tribe has been incorporated in the Constitution of India. Then, with regard to this tribal in mainland India, what we call Adivasi and tribals of Northeast India, what is the difference? Differences is given in Article 244. In Article 244, those tribals in mainland India, their area it is known as scheduled area. But tribal in Northeast, particularly under 6th schedule provision, their area is known as tribal area. That means those tribals from mainland India, though they are tribal, their area cannot be called tribal area as per the provision of the Constitution of India. And for these scheduled caste and scheduled tribe, in order that they may be able to protect their rights and in order that they may be able to exercise their constitutional rights properly. In Article 338, in Article 338, National Commission for Scheduled Caste has been established. And this National Commission for Scheduled Caste comprised of chairman, vice chairman, and other members. And these chairperson, vice chairperson, other members, they are appointed by the President of India. And any issue concerning these exploitation and discrimination of scheduled caste should be complained and remedied by the National Commission for Scheduled Caste. Likewise, in Article 338A, there is also provision for National Commission for Scheduled Tribe. So, this National Commission for Scheduled Tribe, the composition is same as that of National Commission for Scheduled Caste. And any complaint and discrimination concerning this scheduled tribe can be raised and can be taken up by this National Commission for Scheduled Tribe. So these two commissions have been incorporated in the Constitution for protecting the rights of the scheduled caste and scheduled tribes. And now we shall come to the Scheduled Caste, Scheduled Tribe Prevention of Atrocities Act 1989. And different acts have been included in my lecture, but I'll go briefly, if not there is limited time. And even one act will be enough. One act, for clear definition of one act, more than 30 minutes will be required, but I'll try to go brief. So this Scheduled Caste, Scheduled Tribe Prevention of Atrocities Act 1989, it was enacted by Parliament in Act number 33 of 1989, and it became effective in the whole of India with its publication in the Gazette. But it is not applicable in the state of Jammu and Kashmir, because Jammu and Kashmir has its own constitution. If the Jammu and Kashmir Legislative Assembly does not first approve it, it cannot be implemented in Jammu and Kashmir. Then, with regard to this atrocity against scheduled castes and scheduled tribes, so any atrocity against the scheduled caste and scheduled tribes, the following atrocities against scheduled castes and scheduled tribes can be punished with imprisonment for a term which shall not be less than 6 months, but which may extend to 5 years, and with fine. So these are the following atrocities. So these under mentioned atrocity against scheduled caste and scheduled tribe can be punished with imprisonment from 6 months to 5 years and with fine, depending upon the crime. Then what are those atrocities? Number one, if a person forced scheduled caste and scheduled tribe people to drink or eat inedible or obnoxious substance. If scheduled caste or scheduled tribe is forced to drink something which is not drinkable or which is obnoxious substance, that fellow can be imprisoned from 6 to 5 months with fine. And number two, if any act or injury is caused to scheduled caste or scheduled tribe by dumping excreta, waste matter, or other obnoxious substance in the premises of the scheduled caste and scheduled tribe residents, so the same punishment. Then, forcible removal of clothes from scheduled caste, scheduled tribe member, or parade him naked with painted face, or any other similar atrocity that can also be punished with imprisonment from 6 to 5 years with fine. Then, wrongfully occupied or cultivate the land owned by scheduled caste and scheduled tribe, the same punishment. Then, wrongfully dispose or drive out scheduled caste and scheduled tribe member from his land, the same punishment can be given to him. Or if someone compels member of scheduled caste and scheduled tribe to do begging or to do forced labor, then the same type of punishment can be given. Or if anyone intimidate or if anyone wants scheduled caste and scheduled tribe people to vote or not to vote for particular candidate or political party, such person who gives such warning can be imprisoned from 6 months to 5 years with fine. Then if criminal case or legal proceeding is wrongly proceeded against scheduled caste and scheduled tribe, the same type of punishment can be given. Or give false information. If wrong information or false information is given to any public servant by which injury can be caused to scheduled caste and scheduled tribe people, that person who gives wrong information, he can be imprisoned the same punishment, 6 months to 5 years with fine. Then, if a person intentionally inserts with the intention to humiliate scheduled caste and scheduled tribe people in public places, the same type of punishment is given. Or assault or use force to women belonging to scheduled caste and scheduled tribe, the same punishment is given. And if someone is in good position to dominate the will of scheduled caste and scheduled tribe women, and if he uses his position to exploit sexually or in other ways the scheduled caste and scheduled tribe women, that person who does that wrongful act can also be imprisoned from 6 months to 5 years, then with fine. Or if any scheduled caste or scheduled tribe locality, the water which they use, which they drink, has been spoiled with some other substances, the one who did that should get the same type of punishment. Then, if scheduled caste and scheduled tribe are denied the use of customary rights and they are preventing to visit certain public resort, then the same type of punishment should be given to the one who did atrocities. And if scheduled caste or scheduled tribe people have been driven out from their house, village, or place of residence, the one who drive out those people, he should get the same punishment. That means imprisonment for 6 months to 5 years with fine. So those are the punishment, those are the penalty can be given by law code to anyone who committed atrocities or wrongful acts against scheduled caste and scheduled tribe people. You may wonder why these things are laid down. Because these things are happening. We are in tribal society, we don't know. But these things are really happening in the plain society, in mainland India. And because of that, for preventing that these things should not happen again, it has been laid down in the guideline. Then, if anyone who is not from scheduled caste and scheduled tribe community commit atrocities against scheduled caste and scheduled tribe, anyone from non-scheduled caste and scheduled tribe community who committed wrongful act or who give false fabricated evidence to convict scheduled caste and scheduled tribe person, that person can be punished with death sentence. For example, scheduled caste or scheduled tribe people who does not commit any wrong. So wrong evidence has been given by someone. And because of that wrong evidence, scheduled caste and scheduled tribe person was convicted. If such thing happened and it was proved, the one who gave that wrong evidence, he can be punished with death sentence. Then anyone who gives false evidence to convict scheduled caste and scheduled tribe people in capital crime, that person can be punished with imprisonment for not less than 6 months. Then it can be extended up to 7 years. And if someone commits mischievous things by burning the scheduled caste and scheduled tribe locality or keeping some explosive to destroy the scheduled caste and scheduled tribe community, that person can be punished with imprisonment from 6 months up to 7 years. And if a person does something so that the building or place of worship of scheduled caste or scheduled tribe people can be destroyed, that person can be punished with life imprisonment and with fine. And if any person wrongly initiated scheduled caste and scheduled tribe people to be convicted under 45 of Indian Penal Code, he can be punished with life imprisonment. And any public servant means we know government servant. If any public servant commit offense against scheduled caste and scheduled tribe, he should be punished with imprisonment not less than 1 year, and it can be extended depending upon the type of offense. That's why, in order that all these preventive measures can be taken up, state government of different states, in consultation with Chief Justice of High Court, can specify each code in the district as special code. And that special code, in that special code, there will be special public prosecutor. And that special public prosecutor in the special code should take up all complaints against the scheduled caste and the scheduled tribe. So, in such a way, these scheduled castes and scheduled tribes, for their protection of their constitutional rights, fundamental rights, and in order that they may be able to live a normal life, these provisions have been incorporated in the Constitution of India. Okay, we will go briefly to this Civil Liberties Act 1988. Actually, originally this Civil Liberties Act, it was enacted by the Parliament as Protection of Civil Rights Act 1955. And what was the main intention of this Protection of Civil Rights Act of 1955? To put an end to untouchability. You know untouchability. I told you the scheduled castes are known as untouchable people. And in the Constitution of India, in Article 17, it is clearly laid down that untouchability in any form should not be allowed. So for Article 17 of the Constitution of India does not allow the practice or the mention of untouchability. But even though it is laid down in the Constitution, high caste people, they still have the intention to disturb, to exploit, and to regard the scheduled caste people as untouchable people. That's why this has been totally rejected. So, in this Civil Rights Act, this act specifically aims to protect the rights of the scheduled caste. Exclusively, this act is for the scheduled caste. The earlier act which we discussed, it was for protection of scheduled caste and scheduled tribe. But this is mainly for the scheduled caste people. That's why, if any person prevents scheduled caste from entering temple or place of worship anyone who did that action, he should be punishment with imprisonment of not less than 1 month and not more than 6 months, and with fine from rupees 100 to rupees 500. Because some people, they said that if the scheduled caste people enter temple, the temple is polluted. And if they enter the public place is polluted. That's why such intention is there. But here in this act, it is mentioned that any person who professes and who advocates that theory, he should be punishment with imprisonment from 6 months, 1 month to 6 months, and fine from 100 to 500 rupees. Then the act also mentioned that any person who committed the following crimes against the scheduled caste people, they should be punished with imprisonment of not less than 1 month to not more than 6 months, and fine from rupees 100 to rupees 500. Then what are those crimes? If someone does not allow scheduled caste access to any shop, public restaurant, hotel, or place of entertainment, then he can be imprisoned from 1 month up to 6 months. Then fine from 100 to 500 rupees. And if any person does not allow scheduled caste people to use utensils or any articles in public restaurant or hotel, that person also should get the same type of punishment. Then in profession, trade or business, if scheduled castes are regarded and if scheduled castes are not accepted as polluted people, the same type of punishment should be given to them. Then use of river, spring, well, tank or water tank or cremation ground or road, if all these are rejected to scheduled caste people, the one who rejected this should be given the same type of punishment. I mean, social function. Then, other than that, so these are the following actions. So anyone who is indulged in these atrocities or this discrimination against scheduled caste people, they should get punishment, imprisonment from 1 month to 6 months, then fine from 100 to 500 rupees. Then, other than that, if scheduled caste people are not to use certain jewelry, or if they are not allowed to occupy residential premise in locality, or if they are not allowed to observe certain religious custom, that means those persons who do that action, the same type of punishment should be given to them. And any person who does not allow scheduled caste people to be admitted in hospital, to be admitted in dispensary, and to be admitted in educational institution, that person can be given punishment with imprisonment from 1 month to 6 months and fine from rupees 100 to 500. And not only that, any person who refuses to sell goods to scheduled caste community on the ground of untouchability, or any person who injures or molest or discriminates the scheduled caste people, or who encourage the idea of untouchability, they can give it even punishment by imprisonment from 1 month to 6 months and fine from 100 rupees to 500 rupees. And any locality or village which shows disregard to the scheduled caste community can also be given collective fine by the court. In such a way, central government has to get report from different states government with regard to the welfare of the scheduled caste, and this the central government should give the report annually to the parliament. Okay, now we shall come to the last act, Forest Rights Act 2006. And what is meant by this Forest Rights Act 2006? The scheduled tribes and other traditionally forest dwellers, recognition of Forest Rights Act 2006 was enacted by Parliament, and it was assented by the President of India on 29 December 2006. So this act also, from the moment it was published in the Gazette of India, it extends to the whole of India except the state of Jammu and Kashmir. And this act was notified in the Gazette on 2nd January 2007. Then, what is the main aim and intention of this act? The main aim and intention of this act is that the forest rights of the tribal people and forest dwellers should be recognized. What should be forest rights? Forest rights means tribal people who used to collect some edible items from forest, isn't it? That is our forest rights. Other than that, there are many other things which we got and derive from forest. That's why for recognition of those rights, this act was passed. Not only the tribal people, other non-tribals who live in the forest area. Here, their rights are also protected. Okay, let me try to go brief. If not, time will not permit. Then, what are the forest rights? What are the rights of these forest dwellers? Right to live in forest land. The right to cultivate, the right to do cultivation in forest land. Then, not only that, to derive certain important resources from forest. Then, right of ownership, access to collect, use and dispose of minor forest products. And not only that, to do grazing and traditional, seasonal resources or pastoral work in the forest. Then, over and above that, those who habited the forest area, they also have like certain other rights, like ownership of the land, ownership of the land which they own, the land which they utilize. Then here, by these rights, this Act of Parliament also recognize the rights of local government. Local government in the sense, autonomous government, like autonomous district council and regional council under 6th schedule provision. They have certain forest legislation and they have certain forest controlling power. So this Act also recognize the rights of these autonomous district council and regional council with regard to their power over control of forests. And not only that, all other rights are recognized, but two rights of the forest people, tribal people, are restricted. What are those two rights restricted? Trapping animals and hunting in the forest. Why? So those two rights are restricted because for protection of environment and wildlife, those two rights are restricted. They can derive any resources. They can derive any edible items also. They can utilize the resources of the forest, but trapping animals and hunting, these are the two main hobbies of the tribal people. But these two main hobbies of the tribal people are restricted by this Act. So, and with regard to ownership of land in the forest area, the Act says that any tribal people or forest dwellers who live in that area or forest area prior to 13 December 2005, they should be given ownership. But those who occupy the land after 13 December 2005, they should not be given ownership. So, the main intention of this Forest Rights Act is, as I have said, to recognize the forest rights of the tribal people and other forest dwellers. Then, in the Forest Conservation Act of 1980, it is laid down that even if trees are cut down in some government installations, it is said that more than 75 trees per hectare should not be cut down. But this is very difficult to follow and abide by also. And this act, then who hold the main responsibility for governing this legislation? The main responsibility is with the Gram Sabha. Gram Sabha is what we have, local council and village council in Mizoram. So the grassroots democratic governance in Panchayati Raj system. As we know, Panchayat has 3 types. In village level, it is called Gram Panchayat. Then in sub-divisional level, it is called Panchayat Samiti. Then in the district level, it is Jila Parishad. That's why the responsibility for governing and looking after all these provisions, it is vested upon the Gram Sabha. What we have, local council and village council in Mizoram. Then, if anyone is not satisfied with the judgment and ruling and order of this Gram Sabha, he or she can approach sub-divisional level. And that sub-divisional level should be approached within 60 days of the order of the issue of order by the Gram Sabha. And if anyone is still not satisfied with that sub-divisional level, he or she can approach the district level. That's why, in order that this Forest Rights Act of the tribal can be exercised properly, there is Gram Sabha which control the activities. And above that, there is committee at the sub-divisional level, then district level, then there is one committee at the state level, which is formed by the state government. And the committee at the state level monitor the whole activities within the state. And for governance and control of this Forest Rights Act, the main nodal agency is Ministry of Tribal Affairs, Government of India. So from Ministry of Tribal Affairs, Government of India, order has been passed to the state level to district level, then from district level to the village level, Gram Sabha. So that is more about the Forest Rights Act. And we have discussed 3 acts, as I've said. And these 3 acts have been enacted and have been implemented for protecting the vulnerable groups. As I've said, there are many vulnerable groups, but our main focus is upon the scheduled castes and scheduled tribes. Okay, with this, let me end my lecture. Thank you.
Thank you, Professor, for enlightening us with the 3 acts. I know it is very tough to explain all this within a very short time, but he made it very clear to us. And in the 3rd semester, you have social policy and social legislation, so it's not one paper. And these are very important for that paper. So now, let us open a time for discussion. If anyone wants to ask any question, let us open the floor for that.
We are all aware of the incidents that happened recently on September, and under the Atrocities Act, you mentioned that if any individual committed crimes against STs, such as forcibly removing clothes, is the act still applicable if the crime was committed by his fellow STs and STs?
Yeah, in that regard, so to say, both the parties, if both the parties are from ST, it is different. But that can be taken up in normal law code. Instead, if the one who committed the crime be from the non-scheduled tribe, it may be serious. Let me tell you one experience of my friend who is professor in University of Hyderabad. One of my friend in University of Hyderabad, he become professor in 40 plus. He is very young. And that's why he is, so to say, the lone tribal here. And many of his senior colleagues, they are jealous of him. That's why one of his senior colleagues, senior professor, charged him with plagiarism where he did not commit anything. Then what did he do? I didn't commit any plagiarism and I didn't do any such thing. But if you charge me with these things which I never do, I'll approach National Commission for Scheduled Tribes. He gave that warning. And after that, he said that professor repeatedly asked for forgiveness, then we signed agreement. That's why you are now here, and some of you may go out to mainland India for service and other things, and you may mix up with many plain people. And at that time, you should be aware of what protection has been given for the scheduled tribe. We should be aware of it. And as I've said, in case if both the parties are ST or both the parties are SC, it may be different. It would be better to approach in the law code. But as I've said, if the victim is from SC, ST, or the one who committed the crime is from non-SC or non-ST, in such case, the matter can be taken to the National Commission for Scheduled Tribe or National Commission for Scheduled Caste. But if it is, they are both from SC or ST, that means in that case, the normal code will be the best procedure.
Any more? You can have one more if you want. Okay. Thank you for the good participation. And to end the session, we thank Professor Jay Dogan for the nice lecture that he has given us. I hope we all get what he wants to tell us, and we all get the importance of the acts that is being discussed today. Once again, we thank Professor, and also thank you all the participants here who listened to that lecture back.
Good afternoon, everyone. I'm the distinguished chairperson here and all the students. It's a nice opportunity, and I thank you for the opportunity. But, however, I wouldn't call myself an expert in the area, okay? Because I've been teaching administration and gender, but at the same time, since we are planning to do away with this particular course, so this year I haven't concentrated much on it, and especially this time, because of various other obligations, I haven't had the time to prepare. So I have just come very blind, and some of my slides are from my class slides, which I have reduced in number, so that it will be fitting to the time slots that has been allotted. Now, so what we're going to talk about is the Convention on the Elimination of All Forms of Discrimination Against Women. The name itself already tells us what it's going to contain. Okay, so why this is so important and why it is so relevant is because it includes all kinds of discrimination, which you can know right from the name. Now, this this convention is also known as the Women's Bill of Rights, and it was adopted in 1979 by the General Assembly by a vote of 132 to none. Okay, so all those present voted for this particular convention, and by the 3rd of September 1981, it came into force. Now, the countries, whichever countries ratified this convention, they have their obligation. They are obligated to protect the women. They are obligated to end all forms of discrimination against women, and they are obligated to promote equality both in the private sector as well as in public life of a person. Now, as far as we can know, the information that we can get is that it has been ratified or acceded by 187 countries, which comprises about 90% of the UN membership. Okay, and 6 countries have not ratified, and surprisingly here we find one nation, which is one of the most developed nation, which has not ratified the CEDAW, that is the United States. Okay, however, what we find is in certain states of the United States, though the United States as a nation has not adopted and has not ratified this convention, certain states have taken it up and have implemented CEDAW in their particular state. And so that is the condition, and the rest are like Iran, Somalia, Sudan. What you can see from this is that they are mostly the small states as well as very secular states. Okay, and one UN non-member state has not acceded to the convention. That again is the Holy Vatican City, because we know that many of the religious teachings do not really accept equality between men and women. Okay, so that could be one of the reasons. Now, CEDAW has a preamble, and it also has 30 articles. Article 1 to 5 is regarding the general framework of the convention. Article 6 to 16 is regarding specific substantive issues, and Article 17 to 22 is about the committees and the procedures. 23 to 30 is about administration and the interpretation. What we find here is that there are 3 main groups of articles. One is regarding the nature and scope. Can we go back first? So in that, what we find is it is mainly about, one group is mainly about the nature and scope of the state's obligation. Okay? And the second is the targets of specific forms of discrimination. What are the discrimination? What measures the state has to take up in order to fight those discrimination and to put an end to those discrimination. And the third group would be the procedural and administrative matters, so such as what is the reporting system, how reports are to be made, how clarifications are to be made, and all those. Okay. So what we find is, as we have already mentioned, there's a preamble and the 30 articles. In the preamble, we find that it acknowledges that there is an extensive discrimination against women throughout the world. Okay, so in spite, especially in the Mizo community, what we find, what I have found and experienced is also that when I ask my students, many of them say, even the girls themselves will say there is hardly any discrimination. But when we really think about the life of a person, even in the Mizo society, we find that discrimination still exists right from the time of the childhood. But at one point I want to say here is that I'm not a feminist. Okay, I don't really believe that there should be absolute equality, because we ourselves may not want absolute equality. When we still expect men to open the doors for us, we still like it, isn't it? We still like them to pull out the chairs for us. Then we may not really want absolute equality. That is one factor, but in spite of that, the empowerment is required, and we should think more of empowering the women, because women comprises half of the population, more than half of the population of the world. So if half of the population are not empowered, the world cannot be empowered. Okay? Also, we know that when women are not empowered, women are the people who takes care of the children, of the family, the children will not be empowered. So women empowerment influences the children also, and that is why it is important. Okay, so when we think of the Mizo society, if I ask you, do we think we are empowered? Do we think we are equal? What would be the answer? Do we have a yes? You might say so, isn't it? But what I used to say is that think of your childhood. When you are a child, a girl child is expected to stay at home, help around with the housework, whereas a boy child is hardly ever expected to help around. They can go out and play. They are expected to sit around in the house, isn't it? Not help around, but sit around. When you get older, women do not really get to choose their partners. In fact, it is the men who have the option of choosing and coming and courting you. You don't have the option of going out and courting men, isn't it? So then you can't get married. Women have to leave their household, go to the groom's house and stay with people you have never known in your life, right? If you happen to get pregnant before marriage, women are condemned for being pregnant before marriage. Men are not. In case you get married and get divorced, nothing will matter for the men, but women are always stigmatized. Isn't it? And all sorts of comments and all these things will come to you. Okay? And if your partner dies before you, for men, the entire family will be searching for a partner. But for the women, if they get married again, so that is the kind of attitude. In spite of that, we can't really say, right from the cradle to the grave, even in the Mizo society, we have this kind of discriminations that are still in existence. Okay? Then coming back to the topic, so this particular kind of discrimination, all kinds of discrimination that exists throughout the world is recognized by this convention. And another very important thing is that it emphasizes that these kind of discriminations violates the principles of equality of rights and respect for human dignity. Okay? Next slide, please. Now, in the first article, we have the definition of discrimination, where it guarantees that women should have equal recognition, equal enjoyment, equal exercise of all human rights, all kinds of human rights and freedoms. Okay? And these kinds of human rights and freedoms are not only in one particular spur of life, but in the political aspect, in the economic aspect, social aspect, cultural aspect, civil aspect, domestic, and any other which is not specifically mentioned. Okay? So it says, and any other fields. That means even if it's not specifically mentioned, it comes under this particular convention. So, and again, it also says that it is irrespective of whether the person is married or not. Okay? Because when you're married, usually you have, there's one thing that feminists often say, that when a girl get married, even the title gets changed from Miss to Mrs. Whereas when for a male, it remains Mr. So that is the kind of, differences, small but differences that you find among the women. Okay? So they said it is irrespective of the marital status and it should be on the basis of equality with men. Okay? Alright, this next one please. So here is an entire summary of the articles 1 to 16 because that's where we're most concerned with since we are, to know about what it contains, okay? The other articles is more about the procedures, more about the administrative structure, more about the committee that has to be formed. So Article 1 is about the definition of discrimination, which we have already highlighted. Article 2 is about the policy measures, where it says that the states must make, we need to mark the word must, so it's an obligation, okay? They must make laws and rules and also implement policies and practices and change the practices which in order to eliminate discrimination against women. Then third point is about equality. The third article is about equality, where it says that women are fundamentally equal with men in all aspects of life, and the state should also consider this and ensure that women enjoy their human rights as well as the fundamental freedoms. Article 4 is about the temporary special measures, where it talks about affirmative action, or what we call temporary special measures, which can be used and which should be used in order to improve the condition of women. Okay, so here comes things like quotas. Now we have quota system in India also, and this is what can be included under the temporary special measures. Then the fifth one, Article 5, is about the sex roles and stereotyping. Because we know in life, you know, that is what you have to do. If you're a male, this is what you have to do. So that is what we call stereotyping. Okay? So this is about the sex roles and the stereotyping. And the convention, which is a big new thing that comes here, is that it recognizes that the importance of culture and tradition. Okay? No other article based or no other convention or constitution has ever mentioned that culture and traditions influences. Okay? It never pinpoints. But this convention is different because it comes out with the recognition that culture and tradition influences how much of rights women have, and also says that the states should abolish such kind of discriminatory cultural practices, and also should stop the stereotyping of the sex roles in terms of the women. Next slide. Then Article 6 is about trafficking and prostitution, where it says that the state, when we say the state here, what we need to know is the nation, okay? And when we say nation, again, we need to know it's only those nations which have ratified the convention, those nations which have accepted the convention. So the state parties must take all measures, including legislations, okay? That means it should make new laws to stop trafficking of women as well as exploitation of women. Then Article 7 is about the political and public life, where it says that women should have equal rights to vote. This I think we already have in India also, hold public office and participate in civil society. Now here also still, why it is still stressing on this in spite of almost all the nations in the world, where in spite of the fact that in almost all nations of the world, women have the right to vote, okay? But we find that, you know, in spite of having the right to vote, we ask the participation of women in the public life is still very low, okay? So that is one of the reasons. If you look into the scenario of Mizoram also, we have only one minister, isn't it? Woman minister, and I think she is the third or the fourth in the entire history of Mizoram. So that is the condition. And we have the reservation, but in spite of the reservation also, we still find, even at the local level, it is difficult to get the women out into the public life, okay? So that is why they feel that there is a need to include this. Then the eighth is regarding the participation at international level. Now it says that women should also become part of the representatives of the country at international level, and also work with international organizations on equal basis with men. There should be no discrimination when working with the international organizations. I think this is one aspect where it is very successful, because when you work with international bodies, you don't feel any kind of discrimination, okay? Then ninth is regarding nationality, where it says that women have equal rights with men to acquire, change, or retain their nationality as well as that of their children. And 10 is The Article 10 is equal rights in education, where it says that women should have equal rights in terms right to education, including vocational education and other kind of education. Now this is another very important aspect, because we find that although, like if you see Mizoram University, in most of the departments we find that we have more girls. Okay, but if you see the scenario at the lower level, you find that women are lesser in number, girls are lesser in number in terms of education, especially among the, when you see the entire Indian scenario, you find that among the lower castes in mainland India, and there is a big issue in regards to girls' education. You may be surprised that when we had our research and when we travel around, I have been asking a few people, because this is something I hold close to my heart, where I feel women also should have the right to education. Then when I ask around, I often find people telling me, even in Mizoram, that they tell me to amali ne, lakini apasalan may yaman kal may don long to bangin ye zirtuifa amali ne, di hikan la thwali to Mizoram ako yan. Okay, that is still the situation, and so this highlights the importance. Then the Article 11 is about employment, where it says that women should have the right to work, employment opportunity, as well as equal remuneration. Now this is again another point I want to highlight, because we find that even in developed nations like the United States, they still have a problem where there is equal pay is not given for equal work based on the sexes. Okay? Mizoram upon it when we go for research, what I found is in Tampai area, I don't know if any of you come from there, but in the farms, many of them employ women. So I asked, and they said, because women have to be paid lesser for the same kind of work, and women perform better in, planting the rice. So that is the condition. So remuneration for equal work is still not given in many aspects of life. And discrimination on grounds of marriage, pregnancy, childbirth, and child care is prohibited, which means that there should be provisions. Now we are the lucky ones because we work under the central government, so we have a lot of provisions in terms of child care and childbirth and pregnancy and all those things. But in many areas, especially in the private sector, what has been found in India also is that, what has been found in the Indian scenario is also that, in many of the private sectors, women have given up their jobs because their job demands that they stay for long hours. Their job demands that, they have to sometimes stay even till night, okay? So that's why they have to give up. So that kind of provisions, they said, should be made. Then 12 is about healthcare and planning, family planning. Then I think I should go fast because I need to go to the CEDAW committee. Then economic, 13 is about economic and social beliefs, where equal rights should be given to every woman also, which is equal to men. Okay? In terms of economic and social beliefs, benefits also, there is still a lot of differentiation, a lot of discrimination. We find that women nowadays, even in the ration card, they have started keeping the names of women first, isn't it? Now, this kind of provisions is required because even in the banking services, women cannot get loans and credits because they do not have anything of their own. Because properties of the families are usually kept in the name of the menfolk within the family. Okay, so that is one problem. Article 14 is about rural women, where I think we really still need a lot of empowerment, a lot of measures to improve their situation. 15 is about equality before law, so all persons should be treated equal before law. Again, we say there is law, there is equality. But many times when there are rape cases or when there are misbehaviors against women, they go to the police station to report. Then many times, even they still get raped in that police station also. Sometimes they are not allowed and asked to, go for other measures instead of reporting. Okay, so this kind of situation still arises. And 16 is about marriage and family, where it says that in a family, women should have equal rights in a marriage, and also in regards to family planning, which is again another new aspect, where women have the right to choose whether they would like to have children or not, and how many children they would like to have. Okay, then next slide, we say there is a committee that has been constituted to ensure that CEDAW, terms of CEDAW is implemented by the nations. It is made up of 23 experts and it monitors the implementation. To this committee, every state that has ratified, every nation that has ratified, has to submit their report in regards to what measures they have taken up in relation to the CEDAW. And here, we also have another provision which is named, called the optional provision. Is this, okay, next slide please. Still the next one. Yeah, we have the optional protocol where individuals also can complain against the nation. Okay, against the nation, even individuals and NGOs and other organizations can lodge their complaint even if the state does not work for the benefit of the society, or is not implementing the CEDAW properly. We call this shadow reporting, okay, where from behind the scene, these organizations and individuals can report and bring the state to book at the United Nations level, okay? So this is about the optional protocol. However, this the optional protocol can be utilized only when options have been tried out within the nation, and the nation hasn't taken any much initiatives in regards to it. Yes. Now, I think I should not go to the Indian scenario. Maybe I'll end it here. Significance of CEDAW. Here we find that the sole concern of CEDAW is about the women. It does not talk about equality for men, but rather about women. So it's solely focused on women. Okay, it is exclusively devoted to the gender equality, which is again one of the key elements of the Millennium Development Goals also. And it spells out what are the women's human rights, equality and non-discrimination, and actions which have to be taken so that equality can be brought about. It articulates the meaning also, because we still don't have a proper meaning of sex-based discrimination. Okay, it is this convention which has brought out a proper meaning of discrimination and which has also worked for gender equality. It outlines the comprehensive rights of women in all fields, so it is inclusive of every aspect of human life. It is a tool, as we have said, through the optional protocol to bring the nation to the book at the international level, or more specifically at the United Nations, and it provides, this convention legally binds all the nation states which have ratified it to fulfill, to protect, as well as to respect women's human rights, and it takes concrete three-dimensional view of equality. Maybe I should not do India. Okay. It takes three-dimensional view of equality based on the principle of substantive equality, where it says that it should ensure that the laws that are existing in the nation should not be detrimental to the women. Okay, it should not discriminate women, and they should take measures in every aspect that is needed so as to ensure that women have equality in their lives. Okay, so that is what we mean when we talk about substantive equality. This equality should be equality of opportunity and looking at the condition of the women's lives in the present day. Okay, so maybe I should end here. I have brought a little bit about India, but I think I'm taking up too much of your time. Thank you.